I'm going to start recording, and you should be good to go.
Well, thank you, Ashley. Thank you, Department of Human Services, and thank you to all the CSPs that are participating. Did I miss anybody? CSPs, DHS, DDD, anybody else out there? Sounds like
might have some developmental center folks from SDDC, but I think that should be about everyone.
Okay, good. Well, I appreciate that. As Ashley had stated, I'm Paul Kramer from the South Dakota Office of Attorney General. Within that office, I am in the Medicaid Fraud Control Unit. That's a federally funded spot, or 3/4 of it is federally funded. The state matches the other 25%. Every state except North Dakota has a Medicaid Fraud Control Unit. So we work closely with the federal government. They provide our grant funding, of course, and so we work under the guidelines of the federal government, and there are certain types of cases that we do, certain types of cases that we do not do, and we'll kind of get into that in a few minutes when we start talking about the different kinds of cases. So we have this first screen up. It says South Dakota Mafuku Conversation. So this isn't intended to be me spouting out a bunch of information. I hope this is a two-way street. I understand there's some limitations as to feedback and all that, but I will pause and ask for questions on every slide, and hopefully, if I don't, please remind me to. But hopefully, this is a two-way street. I typically learn as much from doing these presentations as I am able to impart, and that may say something about my ability as a presenter, but I like doing these presentations because I typically come away with more knowledge than I impart. So anyway, conversation. Let's make it a two-way street. And then at the bottom it says working together, because we truly do need to work together, and we'll get into that on the next slide. I assume there's no questions on the first page, so we'll just slide into the second one. So working together. South Dakota Medicaid Fraud Control Unit strives to work with, not against, providers. That's not just true with CSPs. That's true with whether it's a medical doctor, a transportation company that provides Medicaid services, all the various Medicaid providers that are out there. We want to work with providers and not against providers. We also work closely with our local, state, and federal partners, and of course, providers. Of course, our state partners would include Department of Human Services and DDD. It would include Department of Health, Department of Social Services, and then our federal partners would be, again, the Federal Department of Health and Human Services, and under that they have what's called OIG, the Office of Inspector General. Some people call them the Medicare cops. We work very closely with OIG. Again, they provide our funding. They provide grant oversight for us. And so we work very closely with them, and we work closely with providers. We've had various cases with various providers, not just in the CSP community, but outside of the CSP community, and I think that the vast majority of them would say that we've treated them fairly. I hope all of them say that. Why do we work closely with these partners and with providers? Because we have the same goal. We want to ensure that we as a state and that providers are providing quality care. CSPs generally are not-for-profit, so we would tend to give, it's one of the factors we consider, we would tend to give a CSP a little more room for error, if you will, on the billing side, because generally no one is profiting directly from billing errors or fraudulent claims. So that's that for-profit versus not-for-profit sort of analysis that we do. Another factor for us to consider is CSPs are assisting vulnerable persons. We understand that this is not an easy job that CSPs have, and there are a lot of challenges. I would assume that one of the biggest headaches, if not the biggest headache, is finding employees that will do the difficult job that needs to be done for the amount of money that you can pay them. And so we understand that, and the vast majority of your services are going to be provided by these employees, and so that, I assume, is the biggest challenge for any CSP, is finding employees who will do a good job for the amount of money you can pay them. So, understanding these challenges that CSPs have, we do not expect perfection. We understand that bad things will happen. Bad things happen on our end too, so we get it. We do, however, expect open and honest cooperation, and that's kind of where the CIRs come in, right? When bad things happen, when reportable events happen, that's the importance of filing the CIRs and getting that information to the Department of Human Services, and in some cases local law enforcement, if it's, if there's some sort of, for example, like a criminal assault type situation, we need to get those local law enforcement folks involved quickly. So I'm going to pause here for a minute. Anybody have any questions or comments on this slide number 2? Okay, I'm going to go on to slide number 3. So the topics I want to discuss today, we're going to talk about the CIRs, and I mentioned before, we work on sort of a specific set of cases because our federal directives, our federal guidelines, our federal grant restrictions sort of limit what any mafuku can do to essentially 3 issues. Billing issues, or provider billing issues. We don't handle recipient fraud. That's handled by a department within DSS. So number 1 would be billing issues, and I have under that errant or improper claims or provider fraud. The second type of case that we can work on, and we're gonna touch on all of these in more detail, abuse or neglect. Right? That's a situation where abuse, of course, would be an affirmative act, where perhaps an employee at a CSP would slap a resident. Okay, that's the most obvious one. Neglect would be failure to provide care, right? And that kind of dovetails into number 3, the failure of care or the inadequate services type of case that we look at. Any questions or comments on any of these topics? I am going to throw in, as long as we're on here, because it is a type of case that we look at occasionally as well, that would be if hypothetically a staff member at a CSP were to get a hold of somebody's checkbook or a debit card or just flat out steal money from a client, we can look at those cases as well. And I apologize that I did not get that on here. A lot of times, frankly, those are handled by local law enforcement, depending on the amount. But it is a type of case that we can handle as well. I'm going to move on to slide 4 here. Okay, so we had the three issues. The first one was billing issues. We'll talk about some specific cases here, not using any names of facilities or anything like that. We have dealt with a case within the last year regarding a billing issue involving a provider that was billing two separate programs concurrently for the same services. DDD does their standard audits. They came across an issue with a particular provider. They worked with the provider. The provider was very cooperative. And we worked with that provider then, and we recovered, it was just under $30,000. Now, we did not, in that case, collect more than the amount that had been improperly billed. We can do that. Our state statutes allow us to get what we call treble damages, T-R-E-B-L-E, which is 3 times. So hypothetically, you know, we've done cases. We did I'm going to go on a side road here. We did a case against a counselor in Madison about a year ago that has nothing to do with CSPs. His name was Sean Mills, and we figured he had misbilled about $9,700. We tripled that. He had to pay back $27,000, and he also pled guilty to a felony. A lot of that depends upon intent. You know, Mr. Nils, we felt, profited directly from filing claims where he was allegedly providing services, purportedly providing services, submitting the claim, but he had not provided those services. So, go ahead. Go ahead. Did someone have a question?
If not, maybe we could all make sure that our lines are muted. I think people are still getting on and off, so that might have been noise.
Okay, all right. Anyway, so that was an example of a case where we did impose a multiplier. We imposed, the damages were about $9,700. The provider had to pay $27,000. Okay. In the cases that we did involving the two programs being billed concurrently for the same services, you know, we don't know that anybody profited directly from that, any person. We were happy with the cooperation provided by the facility, so we simply recovered the money that we thought had been misbilled, and both sides signed a settlement agreement, and we resolved that case. Any questions on slide 4? All right, I'm going to move on to slide 5. Abuse and neglect type cases. again, the most common example would be a staff member or a provider at some level engages in some type of inappropriate conduct, slapping, hitting, or threatening. Those can be charged out as like a simple assault, which is a Class 1 misdemeanor. They can be charged out as, depending on the age and the condition of the client, they could be either abuse of an elder or abuse of a disabled adult, which if that's physical abuse, that's a Class 6 felony. So we go down to the second bullet point. There's the mandatory reporting, of course, right? And I've laid out several sections of South Dakota law that deal with mandatory reporting. I would guess that pretty much anybody that works in healthcare is covered by the mandatory reporting requirements. And even if you're not covered as a mandatory reporter, under state law, there's still the DHS requirements for reporting this stuff. So, just as you're talking to employees, I would assume that the message is something along the lines of, if you see something, say something, right? We want to get these incidents reported. The third bullet point I have there is, again, in a severe enough case, we want to contact local law enforcement and Department of Human Services. And the reason for that is, the Medicaid Fraud Control Unit, we're located in Pierre. If you have a facility that's 3 hours away from here, which most of them are, we might not have the ability to get there, especially if it happens after 5. Local law enforcement, I understand different entities, different law enforcement entities will perhaps respond differently than others. I'm just going to use my hometown just because I'll pick on my own hometown. I'm from Spencer, South Dakota. There is no police force there, but hypothetically, let's say we had one. If I report something to the Spencer Chief of Police or the McCook County Sheriff's Office, they may not seem very thrilled to come out and take a report of a staff member who yelled at or slapped a resident or a client. And I get that. But we still need to keep these mandatory reporting requirements in mind. And if you need me to speak with local law enforcement about their willingness or ability to come out and deal with reports coming from your entity, I'm happy to do that. I can't order someone to do X, Y, or Z. They don't answer to me directly, but I'd be at least happy to have the conversation with them. Part of that, again, with the mandatory reporting and with the contacting local law enforcement, would be that, to my knowledge, the vast majority of police departments and sheriff departments, they want to know what's going on in their community. I mean, they don't necessarily want the state coming in and taking over a case that they perhaps could have handled. So we always, as I like to say, I don't like to play in somebody else's backyard without letting them know that we're coming. Now, we have very good relationships. I've not had any bad conduct with any law enforcement in the state of South Dakota. We don't have turf battles here. But we might if I start showing up and working a case without letting the sheriff and or the chief of police police know what's going on, and the state's attorney. So again, you guys have to use a little discretion here too. I mean, if there's the, what's the difference between a tap and a slap? What's the difference between, yelling, "God damn it," or getting in somebody's face and threatening them, yelling, I'm going to take your head off. I'm going to punch you. I'm going to do this, that. There isn't a lot of black and white here. There's a fair amount of gray. And I'll leave it in your discretion as to, do you call the sheriff at 9:30 on a Friday night to come out for someone saying "God damn it"? I don't know that you do. But if if the staff member has their finger in the face of somebody and is making threatening statements to them, yeah, you might need to. And what we want to do, the reason that we want to get law enforcement involved early is because we want to talk to folks. We want to talk to witnesses. We want to talk to the suspect. We want to talk to the victim to the extent the victim is able to communicate. The quicker we can get on that, the better off the case is going to be. If we wait till the next day or 2 days later, if this happens Friday night at 8 o'clock and nobody finds out about it till Monday morning, stories are going to change, and it just looks bad. It looks bad for the facility because they failed to report. We want to get on these quickly. So I'm going to pause here again. Any questions or comments about slide 5?
This is Ashley again, and I think what you had offered in relation to sometimes reaching out to the local law enforcement might be helpful in some situations, because I know I've received calls in the past, from various organizations that say, hey, our relations with law enforcement they're getting a bit strained. We've had to call them maybe the last 3 nights for a certain missing persons, and now suddenly we're calling them for, an allegation of abuse and neglect. But with the 24-hour requirement for mandatory reporting, it often is, on a Friday or a Saturday that phone call is made to the sheriff or the police because, to meet that timeline, because you can't reach DSS or the division until, Monday morning. So that's I think a really nice offer, and so I think sometimes that might be helpful.
Yeah, and whether someone takes me up on that today, it doesn't have to be today. It could be next week. It could be a month from now, a year from now. I'm happy to have that conversation. I think I have my contact information on at the end of the presentation. But yeah, I would have that conversation. I understand law enforcement's perspective on this too. I'll just throw this out there. It's not a CSP, but there's a facility that I'm well aware of law enforcement being tired of dealing with them. Again, it's not a CSP or it's not anybody on this call. I can guarantee you that. It's a private entity that services older folks. Routinely call local law enforcement, and one of the calls involved there was one of the older residents had a lighter, and he wasn't supposed to be smoking, and they called the local chief of police to come tell this guy to give the lighter to them. I mean, now if the guy's standing there with a lighter and a 5-gallon bucket of gas and he's about to torch the place, yeah, that's a different story. But just because a guy has a lighter and you can't get it away from him, law enforcement's going to get tired of those calls, and I get that. So again, Ashley, did you want to throw in anything on the DHS requirements, as long as we're kind of talking about CIRs for abuse, neglect?
Yeah, sure. So with the mandatory reporting, any type of allegation of abuse, neglect, exploitation, it's typically the police or law enforcement that get that call on, Fridays or Saturdays, Sunday mornings, because it's 24 hours or, 24 hours for that type of notification. But it's or the next working day for the division. And so if something happens Friday evening, we would take that call Monday morning, or if it's, something that would occur on Saturday or Sunday, we would take the call Monday. But otherwise, during the week, just, that next working day, we would take the notification, and then we have the verbal notification going to the program specialist, and then within 7 calendar days, we have the critical incident report being due, which is the written version, to the division for review, and that's often what we would then forward on to your office for further review.
Thank you, and I'll kind of jump in on right there. I'm gonna go back one slide here, actually two, because I kind of skipped over this. The CIRs, so we're kind of talking about that now. Obviously, CSPs fill out the CIRs, they send them to DDD. DDD then sends at least some of them over to us. Now some of them fall outside of the 3 types of cases that we have laid out here below. For example, if a family member is allegedly maybe abusing or neglecting a client in the client's home, not in the CSP, in the client's home, maybe on a weekend when they're away from the CSP, you guys still have to report that, right? You have to report that to DDD and possibly to local law enforcement, or
yes.
Possibly. So you have to report that. The only thing I'm saying is some of those may not make it over to Mafuku because we typically deal with providers and staff. We don't do the in-home stuff. And again, that's a federal restriction on our grant. We don't do stuff within private homes because there's other entities that can do that. They want us to focus on facilities. So as Ashley said, yes, you would report that as a CIR to DDD. That particular CIR may not come over to Mafuku. But that doesn't matter so much on the CSP end because you guys have to report it anyway. So when we get the CIRs over here that DDD sends, we will have follow-up questions on some of them. Now, a fair number of these are they're fairly easily resolved. Overnight staff fell asleep. Morning staff came in, overnight staff was sleeping. No one harmed. Well, that happens. There's not much we would do with that, so we close that one out. Again, you have to report it, but that's not something, there's no criminal conduct there. Nobody got hurt. And there's no, I guess, civil liability there either. As far as having to pay money back, no one got hurt, right? Occasionally, though, there will be, we'll get a report. Staff member allegedly slapped a resident. A lot of times, we're reaching back to DDD when we get that report, and the question back to DDD, which then DDD forwards to the CSP, is, was local law enforcement notified? So if you guys, again, in the context of the mandatory reporting and, just wanting to have local law enforcement involved, if there's a physical type assault or or even the threatening type behavior, go ahead and report that to local law enforcement if you would. Again, you got to use some discretion in there. There's no great black and white rules there. There's some gray in there. I get it, but use your common sense, use your discretion, and get a hold of local law enforcement. And the reason I bring that up, again, that's one of the things when we get the CIRs, if we see that, we're going to want to know that question, the answer to that question. Was local law enforcement involved? Because if they went out and did interviews on this deal, we're going to want the reports from local law enforcement. Is the state's attorney already looking at it? Have they already decided, there just isn't criminal conduct here? We're going to want to know the answers to that. So generally, we reach back to DDD. DDD then reaches back to the CSP. Occasionally, we may speak directly to the CSP. Please don't be alarmed. I think we're easy to work with. We're not trying to get anybody in trouble. We just simply have questions that we want some answers to. But we typically run those through DDD. Anything else on that little topic, Ashley, or anybody else?
I was just going to throw out there that there's a couple other scenarios where I don't have the guidelines in front of me, but we've identified, specific guidelines for division use for forwarding on critical incident reports. And so like participant to participant altercations we would forward on. And I think off the top of my head, the other one would probably be any unanticipated mortalities. Those would automatically be forwarded on to Medicaid fraud as well.
That's correct. And again, the vast majority of participant to participant conduct, it depends upon the cognitive level of the participants. It would be hard to, and probably just flat out not appropriate to criminally prosecute one participant for hitting another participant on the head. Now, if that, again, depends on the facts. Perhaps these are very high-functioning folks, and they didn't just give him a tap on the head. He threatened to hit him with a hammer, and then he did hit him with a hammer. That may require a criminal-type case. Clearly, if staff is involved, that's those are the cases that we look most closely at, or the ones that are of most concern. But there are a fair number of the participant to participant. One participant got mad and pulled the other one's hair. We see a lot of those, or slapped him or kicked him or whatever. The vast majority of those we close. We still want to see them. You still have to report them as CIRs, but I think we all know and we would all agree that those are not appropriate for a criminal prosecution. Part of the reason that we want to look at those too is to ensure that there isn't a pattern. If a particular client is consistently engaging in improper conduct with other clients, at some point we kind of got to ask the question, what is the facility doing to sort of keep the other clients safe from this particular client? All right, so I'm going to jump back to where we were. Anything else on slide 5? All right, I'm going to jump into slide 6. Failure of care, inadequate services. What are we talking about here? This would be, it's probably best defined by example, and we've seen this a couple of times. Failure to properly strap a client in a wheelchair. Okay, then they get on the bus, right, or the van. Van takes off. Van has to make a sudden stop for whatever reason. Client comes out of the wheelchair. Client gets injured. Let's say the client breaks their leg, okay, because they weren't properly strapped in or secured. When we get that critical incident report, we may then forward that over to DSS, who makes the Medicaid payments, and say, you know, maybe you, DSS, want to recoup the money for the cost of this broken leg for this client. Because had that client been strapped in or secured properly, they would not have broken their leg. And DSS may go back to that facility and say, you didn't strap John Smith in properly. He broke his leg because of the sudden stop with the van, and it cost $10,000 for this guy's hospital stay. Facility, you're responsible for that. We're not going to use Medicaid dollars to pay for an accident that was caused by the failure of the facility. And there are, when the Affordable Care Act was enacted several years ago, one of the provisions in the Affordable Care Act involves all providers, all facilities being responsible for situations that they had a hand in creating. For example, in a hospital, if people are continually getting hospital-acquired infections, Medicaid and Medicare may go back to that facility and say, this person came in for an appendectomy. They got their appendectomy, and while they're within the hospital, they acquired an infection. We'll pay you for the appendectomy. We're not paying you for the hospital-acquired infection. And so that's kind of what we're doing along the lines here. We understand that, assuming the staffer did not intentionally try to harm the client, okay? So there's not going to be a criminal charge against the staffer for failing to properly secure. I don't know that it would require a civil case, if you will, against the facility for failing to properly strap that person in, but the facility may have to pay, again, for that cost of the broken leg, maybe even for future increased costs. Any questions on that? And again, we don't expect perfection. We cannot sit in an ivory tower and peer and look down on various providers and facilities and say, well, you should have done this, you should have done that. I mean, we make mistakes too, we get that. But there are certain occasions when, the other side of that argument is we can't expend further Medicaid dollars to pay for care that would not have been needed were it not for the failure of the facility and facility staff to do their jobs properly. A couple other examples I wanted to talk about. One would involve There was a situation where a particular resident at a facility had pica, and pica is a condition where they will that the person will ingest things that are not food. And this particular resident had a pretty significant case of pica and would ingest about anything. So it was a very difficult case. And we understand that in the sense of that person was hard to monitor. There were restrictions in place as far as, watching that particular resident and monitoring that resident to ensure that certain items were not around that resident. That resident got sick, was taken to the hospital. Local hospital sent them to a bigger hospital in a bigger facility or in a bigger city. That hospital performed surgery on that particular resident and found, rubber gloves in that person's digestive tract, and that resident died. And so we went back to that facility and said, we, the state of South Dakota, through Medicaid funds, were paying for services that we don't feel we got. We think that the restrictions on what this resident could get their hands on were not followed. And so that facility, we resolved that case with that facility, and they had to pay some money back. And again, there's nothing personal against the facility. I think they were trying very hard to keep this person safe. And certainly they had no intent to see that this person was harmed. So we don't take the position that you're a bad facility or your staff are bad, but we do have to take the position that but for this happening, but for this person getting their hands on items they weren't supposed to get, we wouldn't have had to pay that $10,000 or however much it was surgery bill at that hospital. Now, I want to make a distinction here. We do not represent families, okay? So if in that example, the family of that resident wanted to pursue that facility for like a wrongful death claim, we do not represent the family. We're not recovering money for the family. We're simply recovering money for the state Medicaid program. Any questions on that? I've got one other example I wanted to touch on. Again, and the facility in that last example is a good facility. I think they're doing a fine job. The people that work there are fine. It isn't personal. We don't, we don't hold this against facilities in the sense of thinking that they're bad or wrong, bad or anything else like that. It's simply, it provides an incentive for the facilities moving forward to do better, and we'll talk about that, I think, on the next slide. The other example I wanted to touch on, there was a facility, and again, it's a fine facility. They have very good folks working there. There was one particular resident that had expressed some threats as far as harming themselves. and that person had in the past made some attempts at harming themselves and had used particular methods, usually involving a plastic bag. And so there were restrictions in place, and the department was paying a higher rate to this facility for sort of a higher level of care, a little more monitoring, if you will. And that particular resident ended up being able to harm themselves by obtaining a plastic bag. And when we worked with the facility and DDD and DHS, it was determined that there were certain steps along the way that hadn't been taken by particular folks that were dealing with that resident. And so again, we took the position that we paid for this higher level of service. We don't feel that we got that higher level of service, and so we requested that money back, and we resolved that case with that facility. And again, fine folks all the way around. They cooperated very well with us, as did the folks in the previous example. We have a job to do as well, and we try to treat facilities fairly when we engage in those types of cases, because again, clearly there was no intent in either case that anyone would end up being hurt. In fact, it was the other way around. They were trying hard to keep those people safe. But again, certain things occur, and we feel that those things were preventable. We take the position that we're probably going to try to recover some money on those. Ashley, anything on that?
No, I think those examples are pretty straightforward the way you explained them.
Anybody else on this particular slide? Okay, so what I was kind of talking about, our goal in pursuing these cases is not simply to recover funds, which is kind of looking back, but to improve the services looking forward. It's an incentive, if you will, for the facilities to ensure that they are providing the services at the level they need to be providing them. And you can use us as the bad guy. If you have staff that don't understand why we have to do X, Y, and Z, you can say, look, if this person harms themselves, if these people harm themselves, if these clients harm themselves, not only are the people getting harmed, but we may have to pay money back to the state. Any questions on slide 7 or the topics we've already discussed? Okay, a couple other issues. There was the Elder Abuse Task Force. Ashley, I know you came to a lot of the meetings. Were you officially on the task force, or were you monitoring for the department?
I believe I was, just providing input based on, the perspective of DHS. I don't know that I was officially on the task force. Okay,
and you would have been in the position of a fair number of folks that, were at the table, and frankly, it didn't matter if folks were on the committee or not, other than for voting purposes, but for providing input. Ashley did a great job of representing the Department of Human Services and representing, the various participants, clients, facilities. It was a very good perspective to have Ashley in on the task force, and we appreciate your input and service on there, Ashley. In any case, we had the Elder Abuse Task Force. There were some changes to the law made. It was a fairly lengthy bill. A lot of it has to deal with financial exploitation. I don't know that a lot of that is particularly applicable to CSPs. One thing is, one of the changes to the law was that in prior years, prior to July 1 of 2016, South Dakota did not specifically define and prohibit emotional and psychological abuse. As of July 1, 2016, a new state statute went into effect. It's 2246.1 sub 4, and that defines emotional and psychological abuse, and it makes it a Class 1 misdemeanor. So now, going back to some earlier examples that we talked about, if a staff member gets frustrated and says, God damn it, I don't think that that's criminal, emotional, and psychological abuse. But if there are those threats, if there's demeaning behavior, and the good thing about the way we drafted the statute was it's not the effect that it has on the victim, because in a lot of cases you'll never know what the effect on the victim is, because they're not able to verbalize if there was an effect and what the effect was. The statute is written so that I'll just read it here quick. Emotional and psychological abuse. A caretaker's willful, malicious, and repeated infliction of a sexual act or the simulation of a sexual act directed at and without the consent of the elder or adult with a disability that involves nudity or is obscene. And of course that could be charged out under like sexual contact or other types of crimes too. Unreasonable confinement, harm or damage or destruction of the property, ridiculing or demeaning conduct, derogatory remarks, verbal harassment, or threats to inflict physical or emotional and psychological abuse directed at an elder or adult with a disability. So, of all the changes that were made in that Elder Abuse Task Force, I think that was probably the one that was maybe of most importance to CSPs. Any questions on the task force or that particular statute? Okay, next topic, OIG exclusion list, the LEIE. I assume most of you are familiar with this. If you're not, I'm guessing your Human Resources Department is. The OIG exclusion list is a list of folks who have been either convicted or for whatever reason they fall into the category of persons who are not allowed to work or to hold positions in facilities that receive federal health care dollars. Okay, so the most obvious example is that the counselor I spoke about earlier, Sean Mills. Okay, he worked at a mental health facility in Madison. He's not a bad guy. He made some bad choices, and he had to pay the consequences for those choices. One of the consequences is when he pled guilty to that felony for submitting false claims to the Medicaid program, he then got placed on the OIG exclusion list. For 5 years, he can't perform certain duties which involve federal health care dollars. Now, it used to be a very clear black and white rule. If a doctor got convicted of provider fraud, went on the exclusion list, they couldn't go work for a hospital as a custodian. They couldn't do anything. The OIG has kind of softened those. It's not so black and white now. There's a little bit of gray in there. But I think the general rule is if you get on the exclusion list, if you're on the exclusion list, facilities cannot hire you. And the importance of this is, there's a couple of things that are important. One, if a facility hires someone that's on the OIG exclusion list, we don't go after the individual that got hired, we go after the facility. Because it's up to the facility to determine if someone's on the OIG exclusion list. You have to check that list. And it's pretty easy to do. They got a website, you punch in their name, and you see if they're on there. Now, I understand people use fake names. They will, maybe they were convicted under a different name, placed on the exclusion list under a different name. Most of the time, if we run into problems with that, it's not because the worker used a fake name. It's that the provider or the facility that employed them didn't even check. And Ashley, I believe Department of Human Services has some requirements about the exclusion list too, correct?
Yeah, there is a requirement that all employees are checked against the exclusionary list, and that's something that we go in and monitor every 2 years during our policy implementation reviews. We review a sample of all personnel files to ensure that, those folks were not on the exclusionary list. There's a, no hits come up when they run that person's name.
Any questions on the OIG exclusion list? I'm going to flip to the next slide, and we'll kind of open this up for questions, comments. I did want to say thank you. We appreciate your efforts on our behalf to assist those folks who need assistance. Again, this is not an easy job. I couldn't be a direct support professional. I couldn't do it. So I understand that the difficulties that they have and that they encounter, and I understand the difficulties that CSPs have in attracting qualified staff who will do the job that needs to be done for the pay that you can offer. I've got my contact information on here. Ashley, will they get a copy of this, or should they just write this down? Or
I can, if anyone wants the contact information, they can email me. I tried to attach the PowerPoint to be able to be downloaded today during the web event, but it wouldn't work for some reason. But we will launch the recording and also the PowerPoint as a PDF onto our website. And Dan Hoblick, our communications officer, is pretty quick about doing that, so it might even be on there yet today, but for sure by the end of the week.
Again, I very much appreciate everybody's time. We'd like to, I was talking about our federal grant requirements. One of those is outreach. And so when we're able to speak with providers like this, it allows us to check that box, if you will. So that's one important thing. The other thing is I just think it's nice to establish that line of communication. Again, we all have the same goal here. Let's work together to ensure that we're providing quality care. And if there's something that we think somebody did wrong, and you guys are saying, look, this isn't the way this works. We understand how you think it should work, but we know a little bit more about this than you do. Please let us know. I mean, you guys are on the front lines, and we just need to have, again, that open, honest communication, and let's not create new problems. Let's solve the problems that are facing us, and to the extent we can work together to resolve those, that's what we want to do. So I'll just shut up for a minute and see if anybody has any questions or comments. And again, thank you.
Well, I'll also say thank you, Paul. Medicaid for All, we really do appreciate the collaborative efforts that you all are open to, because, you know, sometimes we'll get a call that's just like, hey, help us understand this. Like, what does this scenario mean? And so it's just really great to also be able to, you know, share our perspective too and our understanding of a situation, you know, before you make action on it and such. And so we really appreciate that. And of course, the training here today is very good, very beneficial. And I should also mention, we did at one point in time, we tried to get Melanie from the Office of Recoveries to present, but that just didn't work out for us today. So we might, you know, in the future have more information about that. And maybe you mentioned kind of their role, Paul. I couldn't remember if you had or not yet today.
I'm going to flip back a couple slides here when we were talking about so on slide 6, the failure to properly strap a client in a wheelchair. Again, I don't know that our office necessarily is going to pursue a case against a facility in that situation, but DSS may look at that, and that would be Melanie McDonald typically that works those types of situations, and she may come back to a facility and say, you know, we got this claim for the $10,000 for the broken leg. We're not paying that. You guys are going to have to eat that. That's kind of a DSS thing, and that would be the Melanie McDonald side of this thing. And she's you know, from my perspective, very good to work with. You know, and I assume, you know, Melanie's not going to be trying to be overly harsh on any facility. If there are extenuating circumstances, I'm sure that DSS will do their best, and Melanie personally will do their best to work with each facility. It's not as black and white as saying somebody got hurt, they shouldn't have gotten hurt, you're paying for it, not us. It's not that black and white. I'm just throwing this example out there to say there have been situations where DSS, through Melanie McDonald, will, you know, they'll pass those costs on to a facility.
Got it. That makes sense. Thank you. And if anyone has any questions after the call ends as well, please feel free to, you know, send Paul or I an email, and we can get back to you with that information. Yeah, otherwise, I guess it's probably it for today. We can hang on for a couple minutes, too, if maybe someone wants to, you know, mention something as others are logging off and such.
You got a free shot at a lawyer and Ashley. Better take it.
So thanks again, Paul. We appreciate it. But, yeah, we can just hang on for a couple minutes, and then if nothing else, we should be good to go.
Thank you all. Have a great day.